Good afternoon again, everyone. I am Tiffany Daniels. Welcome to another episode of Spilling Tea. Today we are covering part 5 of the JRC on trial back for the April in 2012. Again, as always, this is by Shane Neumeyer. I will make sure, as always, to include the link to what I am going over with you today in the description, as well as the link to the petition to shut down the Judge Rotenberg Center. If you haven't already signed that yet, please take the time to go ahead and do so. Now, if this is the first video on the JRC that you are seeing, please, after this video, go back and look for the video that starts with hashtag Stop the Shock Campaign Reignites and go from there to get a full idea of what exactly we are going over here. Okay, so let's get started. The case for the defense in the trial over the alleged misuse of electronic shock and restraint on Andre McCollins at the Judge Rotenberg Center continued on Wednesday, 18th of April, 2012. After Dr. James Riley's testimony concluded, his attorney, Edward Hinchy, called Dr. Carol Ball, a psychologist, to the stand. In introducing herself, she stated that her specialty was in cognitive behavioral therapy, with a focus on providing treatment to people with sexual behavioral issues. She discussed her experience with using aversives, specifically in treating sex offenders, by exposing them to noxious odors such as ammonia, and in some cases using skin shock at the same time that she presented them with sexually stimulating images in order to reduce physical arousal at the image's content. Oh my God! What the hell? That's insane! This woman's insane! She clarified that she did not use the skin shock device used at the JRC, the graduated electronic decollator, stating that the device could not be used in outpatient practice. Gee, I wonder why. As for her connection with the JRC itself, she testified that she had been hired as a consultant to the program in 1996. However, she decided to not work with it further as it was not a good fit due to difference in the populations that they worked with. Before discussing the case itself, she provided information on the difference between psychiatrists and psychologists, stating that the former relied on a disease model and providing treatment, while the latter focused on learned behaviors with the potential for change. She was also asked about whether a psychotic patient could be a good candidate for the use of aversives, to which she replied, certainly, explaining that cognitive awareness was not required for behavioral modification. Like, this is a group of sick people. What the hell? Excuse me, sorry. Crap's so bad it's making me cough. In support of this, she stated that literature exists that established that aversives have been effective in treating psychotic patients. No, it hasn't. Not if you're a reputable one, there's not. But okay, Karen, go off. In reviewing the records, which had involved her watching all of the video footage as recently as the previous night, and reviewing the various medical records and depositions used in the case, she had focused on Dr. Riley's involvement, namely the time frame of 10:19 to 10:39 a.m. on the 25th of October 2002. Before asking her further questions, Mr. Hinchy asked her to assume a number of facts, which essentially laid out the defense's, or more specifically Dr. Riley's version of the case. Based on the assumed facts, she concluded that Riley followed the rules completely and was completely within the standard of care. Is she out of her mind too? This is starting to scare me. Holy hell. Remind me to never get a doctor in Massachusetts after this. Holy crap. How does this fit standard of care? The hell is wrong with these people? Do they have no humanity? No humanity at all? Sorry, I'll get on with it. She went on to say that his decision to put Andre on the 4-point restraint board had been the humane thing to do. The humane thing to do? These people should have their licenses revoked and be put in the jail. Humane thing to do. Humane. That's humane. And that it showed he had cared about Andre's comfort. Shocking him showed he cared about Andre's comfort. I'll try to get through this. Should have known this was going to be a shit show. And it showed that he cared about Andre's comfort. Furthermore, she was the opinion that Dr. Riley had made a reasonable judgment to continue the use of electric shock on Andre. Is she out of her mind? And that it had seemed appropriate. And that stopping the shocks could have reinforced his tensing up. Due to the shocks. Oh my god, how do these people have fucking medical degrees? Freaking Christ. Interestingly, she described the full body tense-ups as aggressive behavior. Again, how do these people have medical degrees? How do they have medical degrees? If they can't figure out that skin shocks causes full body tense-ups, how are they doctors? Holy shit. This video is not for children. Okay. I'm going to try to read this without interruptions, but I can't make any promises. This is insanity. God. That justified the use of aversives, in contrast to how his treatment plan, allowing the use of electric shock in response to them, classified as health dangerous or self-injurious behaviors. Finally, with regards to Dr. Riley's having left the JRC early in the afternoon and not checking on Andre over the weekend, Dr. Ball concluded that this also had been within the standard of care. This woman's out of her mind. Again, remind me to never get a psychologist from Canton, Massachusetts. Oh my god, the hell. As far as the harm that Andre suffered as a result for the incident, she testified that none of the damage had been permanent. What? He is literally stuck in an institution for the rest of his life. This one guy who was only on one medication and doing fine, working towards living an independent life, is now going to be in an institution for the rest of his life because of what was done that day. And she wants to tell us that damage wasn't permanent. She referred to the hospital records from his stay at the Children's Hospital Boston, which state that he had returned to baseline by the time he went home. Oh my God. In fact, based on his records from the later residential programs, she concluded that he had improved and gained skills. I noted the program he had been attending now has been trying to get him into a more community-based and less restrictive setting. Send good vibes, all. I'm gonna try to get through this without, punching this table, because it would hurt. The cross-examination began with Mr. Novotny calling into question Dr. Ball's qualifications. Thank you! To testify in this case. Namely, he brought out, through questioning, the fact that she had not had an autistic patient in the last 10 years and had not worked with an inpatient setting for the last 25. Ooh. Most of her time, in fact, was not spent treating patients, but rather serving as an expert witness in other cases, many of which are hearings for the purpose of committing sex offenders about to be released from prison to psychiatric facilities. He also attempted to call into question whether she could be trusted to give an unbiased opinion because of her prime consultant work at JRC. You go, Mr. Novotny. Finally, some fucking sense. Again, do not let your children see this video. Mr. Novotny did, however, rely on her experience with working with sex offenders to ask whether a victim of sexual abuse would be re-traumatized by what Andre went through at the JRC. Dr. Ball conceded that it was possible that for a 4-point prone restraint could have had this effect. However, the defendant raised an objection, which the judge sustained, putting an end to this line of questioning. Of course they did. Of course they did. This is insane. How are these people allowed to practice medicine? That had been done on anyone other than a kid with a disability? Let's go on. The plaintiff's attorney also got Dr. Ball to agree that there was no one-size-fits-all treatment, and that a different situation required a different approach in treatment, and possibly a change in the overall treatment plan. She disagreed, however, with the statement that the incident was all that distinct from the other 20 times that Andre had been restrained at the JRC, stating that the only differences had been the number of shocks that Andre received. He shouldn't received a single one. Gonna try to get through this. Still, Mr. Novotny pressed on, eliciting testimony if someone was learning from treatment, this would generally lead to a de-escalation. Oh my God, these people are sick. And the situation with Andre had not, in fact, de-escalated that day. Gee, I wonder why. Specifically at the end of the day, the restraint had gone on long enough and wasn't helping, which is why it eventually stopped. When asked, Dr. Ball stated that she did not know if Andre learned anything that day and stopped tensing up as a result of the adverses being used on him. God's sake! Don't tense up when we're abusing you, okay? That's what you're supposed to learn. Don't tense up. Just take it and be there like a limp doll. That's what this sounds like to me. Is it just me? Is it just me? But stated that she would not in a position to make a determination about when enough had been enough. It shouldn't have happened at all. How about that? Let's make it simple. None of it should have happened at all. That clear enough for you? Mr. Novotny introduced into evidence the behavioral recording sheet used on the day of the incident, which listed the behaviors for which Andre had been shocked. It came out that none of the first 15 shocks used that day had been recorded. Why is that not surprising? Or possibly that the records of them had gone missing. How convenient. However, the purpose for which the introduced document was to show that the rest of, in fact, the majority of the shocks were tensing and screaming, which, contrary to Dr. Ball said on direct examination, were not classified even by the JRC as aggressive behaviors, but instead as self-injurious ones. They're not self-injurious when they are reaction to what you people are doing. You all caused the shocks, which caused the tense-ups. Okay? We good now? How are these people doctors? Let me find where I was again. Sorry, folks. Okay. The discussion turned to whether Dr. Riley specifically had been operating within the standard of care and making the decisions he had. Mr. Novotny asked Dr. Ball whether it was true that Dr. Riley didn't know what the JRC's own policy provided for with regards to how often Andre should have been let out of restraints. Mr. Hinchy objected to this, and after a brief conversation with the judge, the objection was sustained. Of course it was. Novotny then returned to the issue of the psychiatric contraindication for the use of combined aversive interventions that had come up in Dr. Riley's testimony. When asked, Dr. Ball agreed that if an aversive had contraindicated, then it should not have been used. Furthermore, she said that she would in fact be critical of Dr. Riley if he had acted in a way not in accordance with this principle. I still think you should lose your freaking license. When asked what exactly the good care that Dr. Riley had provided had been, Dr. Ball said that he had observed the experts working with the patient. In response, Mr. Novotny asked whether being present or observant was truly sufficient under the circumstances. She defended her statement by saying that talking with Andre about what happened and how he felt at the time would have gone against JRC protocol of not rewarding target behaviors with attention. Oh my God! Targeted behaviors that you all started because you were shocking him for not taking off his coat. Fuck me. Finally, Mr. Novotny focused on Andre's state following the incident. He asked the witness whether she remembered from the records that Andre had not been able to walk out of the room by himself that day, or that he had been reportedly withdrawn and catatonic, curled up in a fetal position, in the hours and days after the incident. He also reminded her of how Andre had kept in waist and leg restraints, which the JRC staff had specified would continue until further notice, and that Andre had been transferred to the Children's Hospital for medical evaluation only at 7:30 the following Monday after remaining unresponsive, crying frequently, and refusing to eat or drink over the course of the weekend. Dr. Ball agreed with Novotny's statement that Andre had continued to be afraid during his recovery, though she qualified this, saying that it has not consistently been the case. At the end of the cross-examination, the attorney argued that the improvements Andre had made in the years since the incident at the JRC had been made in spite of what happened to him, and only Andre's own efforts and his mother's advocacy had allowed this to happen. Amen. The brief redirect examination with Mr. Hinchy sought to establish that Andre had in fact been known to be unpredictably violent without provocation, including on the morning of the incident before he was brought into the classroom. The witness also reiterated that Dr. Riley's decision to put Andre on the restraint board had been the most caring and appropriate way of handling the situation. Caring and appropriate, my ass, you sick son of a bitch. Finally, she defended her testimony as fair and honest, saying that having worked with the JRC had not made her too biased to give a reliable opinion. No, you're just insane. You're just an insane abuse and torture apologist. Bet the Cheney administration could have really used you. The defense next witness was Dr. Robert Van Hine, who is currently the executive director of the JRC and had been, at the time of the incident, the facility's clinical director. As brought out in the beginning of his testimony, he is a board-certified behavioral analyst who's worked at JRC for 22 years. He stated that he is not, in fact, a licensed psychologist, as his degree was in experimental rather than clinical psychology. Really? When asked whether he had been legally allowed to work at the JRC without a license, he replied that he had, but that the state of Massachusetts had forced the JRC to no longer hold him out as a psychologist, as this was against state regulations established sometime during the 90s. This had led to him being named the program's director of clinical services. With regards to the events of the 25th of October 2002, he testified that his involvement had initially been to check briefly on Andre, who was not his own patient, when he heard screaming coming from the classroom Andre was in. He left the room 3 to 4 minutes later, concluding that the members of the staff restraining him were taking good care of Andre. Later, he returned with Sue Parker, the director of programming, to give authorization for staff to shock Andre up to 40 times. Oh my God. Horrible. Horrible. However, at this time, he also temporarily removed TINSEPs from the list of target behaviors for which Andre could be shocked. Following this, he had gone to talk to Dr. Israel, the executive director of the JRC at the time, about the situation. In describing the situation, Von Hayes said that it had been an unusual event in terms of length of restraint and number of shocks Andre had received, and Andre had been presenting differently that day. When asked about Andre's behavior at other times, he said he had seen Andre doing well, and he had never personally seen Andre acting aggressively. However, he was aware that Andre exhibited problematic behaviors upon his admission to the program, and believed that he was a good candidate for aversive treatment. Beyond that, he did not remember anything about Andre in particular, and had not reviewed Andre's treatment plan before it was submitted for court approval. The defense attorney briefly questioned Von Hayes about a part of the video footage in which the JRC staff could be heard laughing. Von Hayes said that he could hear the conversations preceding the laughter only to a certain extent and was not able to testify as to what was actually said. During this part of the testimony, Von Hayes pointed out the people in the courtroom, Carl Weisler, who had been a technician assisting the GEDs in the classroom of Andre on the day of the incident, and who, according to the defense attorney, had made a joke that had prompted the laughter. The discussion then turned more to a general discussion about GED shock device, and how Von Hayes had, in a sense he said, been involved with its development. The device used before it, the self-injurious behavior inhibition system, had provided a shock that had been too weak and too short to have any real effect, according to him. God, these people are sick. No, it needs to be 10 times more powerful than a police taser to be effective for these disabled kids. God, I hate people. Freaking hate people. How do they have medical licenses? How is this okay? He assisted on the clinical end of things in the development of the JRC's own device. The result was the GED, which delivered a stronger shock not just by virtue of the amount of electricity it used, but also because of it came in waves or vibrations. Oh my God! Which made it more painful. He compared the shock to a hard pinch with one's fingernails, an analogy often used by JRC staff and reporters. The defense attempted to have Von Hain demonstrate the GED on himself in court, but Mr. Novotny objected, and the judge agreed with him, keeping this evidence out. Now, since then, folks, I can tell you that it has been reported by outside agencies that those shocks are 10 times more powerful than a police taser. So they can lie all they want. That's no bee sting. As used at the JRC, according to Dr. Van Heim, individual GEDs are tested every day for performance and are calibrated when found to be malfunctioning. The devices are carried by students on backpacks or panty packs attached to the students' bodies with electrodes. They are remotely activated by individual remotes, upon which are the names and pictures of the students with the corresponding devices to prevent shocking the wrong person. In deciding to shock a student, 2 JRC staff members must check the student's daily recording sheet to confirm that the behavior merits use of the GED. After the shock, staff will verbally pinpoint the behavior that led to the shock. Andre, no full body tense-ups. One second, I'm sorry. Missouri allergies are a thing, and they're awful, and I'm not redoing the video, so let me start back where I was. Von Hain testified that this process must be used every single time a student receives a shock. Furthermore, he stated that everything in the facility is recorded by and looked at by the JRC's monitoring department, which consists of senior members of staff. The examination then returned to the events at issue in the case, using the video footage for reference. In many parts of the video, Andre repeatedly saying no or ow or similar phrases without being manually restrained or shocked, which Von Hain characterized as Andre exhibiting verbal behaviors. Really? Really? And being less than fully calm. Gee, I wonder why. While claiming that he could not understand what Andre was saying. At one point, however, the screaming in pain at one particular shock, Andre went silent. Von Hain interpreted this as him calming down as a result of the GED being used. No, dear, that's going catatonic. Ugh. How are they doctors? The defense showed a number of clips in which Andre was offered water and checked on by nurses for his comfort and safety while in restraints. Comfort and safety. There were 3 instances shown in which Andre was offered water, and 2 of these he answered yes. As the defense attorney pointed out, it was impossible to tell from the camera angle whether Andre succeeded in drinking the water. Over the course of the day, nurses checked on his blood pressure, his eyes, which prompted Andre to ask for his glasses, I see better with those, adjusted the restraints on his arm when he complained that they hurt, and inquired as to whether he was okay, which he was at one point replied no. The walkthrough included watching points of the video that having to do with times that staff offered to take Andre to the bathroom. At 1:09 in the afternoon, he was offered a trip to the bathroom and told staff that he did in fact need to go. Shortly after, the staff attempted to put a backpack carrying the GED on Andre, in response to which he started to struggle. Who could blame him? You can go to the bathroom, but you have to wear your other shock pack. He was still more agitated as staff removed him from the restraint board and started to place his arms and legs in other types of restraints in order to move him. During this process, he was shocked 3 times in response to full body tense-ups. Jesus. which only caused him to scream more. Because of his struggling, he was returned to the restraint board and not, in fact, allowed to use the bathroom. In the courtroom, Miss Collins was so upset by watching this, she had to leave the room and did not return while the video was still playing. Who could blame her? The video footage shows that the staff offered Andre an opportunity to use the bathroom again at approximately 3 p.m. that day, almost immediately after which Andre received another GED application. Jesus! At 3:15, a bunch of JRC staff entered the room, and Andre's case manager asked him again about using the bathroom. In response to this, Andre started to struggle and say no again. This only escalated once 4 staff members began process of placing a diaper on Andre, taking his pants off and putting it over his underwear, as well as physically restraining him while he was still on the 4-point restraining board. Andre started to scream, "Ow, help me," as well as "no," which the staff responded by shocking him 4 times. Von Hain testified that this had not been the 30th shock, forcing the staff to wait for further authorization. They would have shocked him more during this process as he continued to engage in target behaviors. Oh my God! Von Hain and Sue Parker with him only entered the room after the staff had succeeded in putting the diaper on Andre. But while Andre was still being both physically and mechanically restrained, he testified again to having given staff to shock Andre up to 40 times. However, he stated that Andre received no further shocks that day, leaving the 31st shock unaccounted for. The testimony of Dr. Van Hain concluded the following day, which I was unfortunately unable to attend. The next blog post will cover almost all of Dr. Israel's testimony. A very small amount was presented that Thursday afternoon, as well as the other expert witness for the defense, an indirect care worker who shocked and restrained Andre on the day of the incident. Every day I do these. And every day it doesn't get easier to read them. I can't, it's like beyond my control to stop my responses while I'm reading through this information for you all. This is extremely disturbing. And people out there like this are allowed to practice medicine. That should concern everyone. That should concern everyone. I need to take a moment after reading through that. I do want to thank you folks for your time this afternoon. Now, we don't get that many views on this channel. The few views that we do get do tend to get removed by YouTube, so please don't forget to hit the like button, hit subscribe, don't forget to hit the comments. I do appreciate your time, and I hope you have a good one. Bye-bye.